Parties to civil actions. Now, who may be parties to civil actions? Under Rule 3, Section 1 of the 1997 Rules of Civil Procedure, only natural or juridical persons or entities authorized by law may be parties in a civil action. Let us discuss this very interesting case of resident marine mammals of the protected seascape Tanyan Strait versus Reyes. Petitioners, collectively referred to as the resident marine mammals in the petition, are the toothed whales, dolphins, porpoises, and other cetacean species which inhabit the waters in and around the Tanyan Strait. They are joined by Ramos and Osorio as their legal guardians and as friends to be collectively known as the stewards, who allegedly empathize with and seek the protection of the aforementioned marine species. So the issue in this case is whether animals or inanimate objects should be given legal standing in actions before courts of law. Petitioners, resident marine mammals, and stewards aver that the court may lower the benchmark in locus standi as an exercise of epistolary jurisdiction. In opposition, public respondents argue that the resident marine mammals have no standing because Section 1, Rule 3 of the Rules of Court requires parties to an action to be either natural or juridical persons. So what do you think? Is this the generation when animals or inanimate objects can have a standing in court? The Supreme Court safely held that the issue of whether or not animals or even inanimate objects should be given legal standing in actions before courts of law is not new in the field of animal rights and environmental law. The primary reason animal rights advocates and environmentalists seek to give animals and inanimate objects standing is due to the need to comply with the strict requirements in bringing a suit to court. Okay? Our own 1997 Rules of Court demand that parties to a suit be either natural or juridical persons or entities authorized by law. It further necessitates that the action to be brought in the name of the real party in interest, even if filed by a representative. It had been suggested by animal rights advocates and environmentalists that not only natural and juridical persons should be given legal standing because of the difficulty for persons who cannot show that they by themselves are real parties in interests to bring actions in representation of these animals or inanimate objects. For this reason, many environmental cases have been dismissed for failure of the petitioner to show that he or she would be directly injured or affected by the outcome of the case. However, in our jurisdiction, locus standi in environmental cases has been given a more liberalized approach. While developments in Philippine legal theory and jurisprudence have not progressed as far as Justice Douglas' paradigm of legal standing for inanimate objects, the current trend moves towards simplification of procedures and facilitating court access in environmental cases. The Supreme Court held that it passed the landmark Rules of Procedure for Environmental Cases, which allow for a citizen suit and permit any Filipino citizen to file an action before our courts for violations of our environmental laws. Although this petition was filed in 2007, years before the effectivity of the Rules of Procedure for Environmental Cases, it has been consistently held that Rules of Procedure may be retroactively applied to actions pending and undetermined at the time of their passage and will not violate any right of a person who may feel that he is adversely affected, inasmuch as there is no vested rights in rules of procedure. Moreover, even before the Rules of Procedure for Environmental Cases became effective, the court had already taken a permissive position on the issue of locus standi in environmental cases. In the case of Oposa versus Factoran, the Supreme Court allowed the suit to be brought in the name of generations, yet unborn, based on the concept of intergenerational responsibility insofar as the right to a balanced and healthful ecology is concerned. Furthermore, the Supreme Court said that the right to a balanced and healthful ecology, a right that does not even need to be stated in our Constitution, as it is assumed to exist from the inception of humankind, carries with it the correlative duty to refrain from impairing the environment. Okay, so now going back to the question of whether or not animals or inanimate objects should be given standing in court, the Supreme Court did not directly answer that question. In fact, it did not address that question. The Supreme Court held that the need to give the resident marine mammals legal standing has been eliminated by the rules, which allow any Filipino citizen, as a steward of nature, to bring a suit to enforce our environmental laws. It is worth noting that the stewards here are joined as real parties in the petition, and not just in representation of the named cetacean species. The stewards, Ramos and Osorio, having shown in their petition that there may be possible violations of laws concerning the habitat of the resident marine mammals, are therefore declared to possess the legal standing to file this petition. Okay, let's discuss another case, Ventura versus Militante. Private respondent filed a complaint for a sum of money and damages against petitioner, which reads, Mr. John Uy, proprietor of Cebu Techstar Auto Supply, plaintiff, versus estate of Carlos Ngo, as represented by surviving spouse, Ms. Sulpicia Ventura, defendant. Petitioner moved to dismiss the foregoing complaint on the ground that the estate of Carlos Ngo has no legal personality, the same being neither a natural nor legal person in contemplation of law. In his opposition to the motion to dismiss, petitioner insisted that since the money claim subject of this case actually represents the costs of automotive spare parts or replacements contracted by deceased Carlos Ngo during his lifetime for the benefit or business of the family, the conjugal partnership shall be accountable for the payment thereof. So the issue in this case is whether or not the estate of Carlos Ngo, as represented by surviving spouse Ms. Sulpicia Ventura, has a legal personality. In other words, can we file an action against the estate of a deceased person? The Supreme Court held that, first, Section 1, Rule 3 of the Revised Rules of Court provided that only natural or juridical persons or entities authorized by law may be parties in a civil action. This was the rule in 1982 at the time that private respondent filed his complaint against petitioner. Then in 1997, the rules on civil procedure were revised, but Section 1, Rule 3 remained largely unaltered, except for the change of the word judicial to juridical. The Supreme Court explained that parties may be either plaintiffs or defendants. The plaintiff in an action is the party complaining, and a proper party plaintiff is essential to confer jurisdiction on the court. In order to maintain an action in a court of justice, the plaintiff must have an actual legal existence. That is, he, she, or it must be a person in law and possessed of a legal entity as either a natural or an artificial person, and no suit can be lawfully prosecuted save in the name of such a person. The rule is no different as regards party defendants. It is incumbent upon a plaintiff, when he institutes a judicial proceeding, to name the proper party defendant to his cause of action. In a suit or proceeding in personam of an adversary character, the court can acquire no jurisdiction for the purpose of trial or judgment until a party defendant, who actually or legally exists and is legally capable of being sued, is brought before it. It has even been held that the question of the legal personality of a party or party defendant is a question of substance going to the jurisdiction of the court and not one of procedure. Further, the Supreme Court held that the original complaint of petitioner named the estate of Carlos Ngo as represented by surviving spouse Ms. Sulpicia Ventura as the defendant. Petitioner moved to dismiss the same on the ground that a defendant, as named in the complaint, had no legal personality. The Supreme Court agreed. It held that neither a dead person nor his estate may be a party plaintiff in a court action. Okay? A deceased person does not have such legal entity as is necessary to bring action, so much so that a motion to substitute cannot lie and should be denied by the court. An action begun by a decedent's estate cannot be said to have been begun by a legal person, since an estate is not a legal entity. Such an action is a nullity, and a motion to amend the party plaintiff will not likewise lie, there being nothing before the court to amend. Considering that capacity to be sued is a correlative of the capacity to sue, to the same extent, a decedent does not have the capacity to be sued and may not be named a party defendant in a court action. Second, it is clear that the original complaint of private respondent against the estate of Carlos Ngo was a suit against Carlos Ngo himself, who was already dead at the time of the filing of said complaint. At that time, and this, private respondent admitted no special proceeding to settle his estate had been filed in court. As such, the trial court did not acquire jurisdiction over either the deceased Carlos Ngo or his estate. To cure this fatal defect, private respondent amended his original complaint. In his amended complaint, private respondent deleted the estate of Carlos Ngo and named petitioner as the defendant. When petitioner in her comment to the amended complaint reasoned that the conjugal partnership of gains between her and Carlos Ngo was terminated upon the latter's death, and that the debt which he contracted, assuming it was a charge against the conjugal property, could only be paid after an inventory is made in the appropriate testate or intestate proceeding, private respondent simply reiterated his demand that petitioner pay her husband's debt, which he insisted redounded to the benefit of everyone in her family. In this, the Supreme Court held that it is true that amendments to pleadings are liberally allowed in furtherance of justice, in order that every case may, so far as possible, be determined on its real facts, and in order to speed the trial of causes or prevent the circuitry of action and unnecessary expense. But amendments cannot be allowed so as to confer jurisdiction upon a court that never acquired it in the first place. When it is evident that the court has no jurisdiction over the person and the subject matter, and that the pleading is so fatally defective as not to be susceptible of amendment, or that to permit such amendment would radically alter the theory and the nature of the action, then the court should refuse the amendment of the defective pleading and order the dismissal of the case. As correctly ruled by petitioner, the Supreme Court held that the conjugal partnership terminates upon the death of either spouse. After the death of one of the spouses, in case it is necessary to sell any portion of the conjugal property in order to pay outstanding obligations of the partnership, such sale must be made in the manner and with the formalities established by the rules of court for the sale of the property of deceased persons. Where a complaint is brought against the surviving spouse for the recovery of an indebtedness chargeable against said conjugal property, any judgment obtained thereby is void. The proper action should be in the form of a claim to be filed in the testate or intestate proceedings of the deceased spouse. In many cases, as in the instant one, even after the death of one of the spouses, there is no liquidation of the conjugal partnership. This does not mean, however, that the conjugal partnership continues, and private respondent cannot be said to have no remedy. So, since the creditor cannot go after the conjugal property, what is the creditor's remedy? Under Section 6, Rule 78 of the Revised Rules of Court, he may apply in court for letters of administration in his capacity as principal creditor of the deceased, Carlos Ngo, if after 30 days from his death, petitioner failed to apply for administration or request that administration be granted to some other person. So again, the estate has no personality to sue and be sued in an ordinary civil action. The remedy of the creditor is to institute a special proceeding to claim against the estate of the deceased. How about the legal personality of a sole proprietorship? Let's discuss the case of SC Mega World Construction Development Corp. versus Parada. In this case, petitioner SC Mega World Construction and Development Corporation bought electrical lighting materials from Genlight Industries as sole proprietorship owned by Engineer Parada, or the respondent, for its read-write project in Canlubang, Laguna. The petitioner was unable to pay for the purchase on due date. So, respondent, Engineer Parada, filed a suit to collect from the petitioner the balance plus damages, costs, and expenses. On appeal to the Court of Appeals, the petitioner argued that the trial court should have dismissed the complaint for failure of the respondent to implead Genlight Industries as a proper party in interest, as provided in Section 2, Rule 3 of the 1997 Rules of Civil Procedure. So the issue in this case is whether Genlight Industries should have been impleaded as a party plaintiff. The Supreme Court held that a sole proprietorship has no juridical personality separate and distinct from that of its owner, and need not be impleaded as a party plaintiff in a civil case. On the question of whether Genlight Industries should have been impleaded as a party plaintiff, the Supreme Court held that Section 1 of Rule 3 of the Rules of Court provides that only natural or juridical persons or entities authorized by law may be parties in a civil case. Article 44 of the new Civil Code enumerates who are juridical persons. The following are juridical persons: the state and its political subdivisions, other corporations, institutions, and entities for public interest or purpose created by law. Their personality begins as soon as they have been constituted according to law. Next, corporations, partnerships, and associations for private interest or purpose to which the law grants a juridical personality, separate and distinct from that of each shareholder, partner, or member. The Supreme Court held that Genlight Industries is merely the DTI-registered trade name or style of the respondent by which he conducted his business. As such, it does not exist as a separate entity apart from its owner, and therefore it has no separate juridical personality to sue or be sued. As the sole proprietor of Genlight Industries, there is no question that the respondent is the real party in interest who stood to be directly benefited or injured by the judgment in the complaint below. There is then no necessity for Genlight Industries to be impleaded as a party plaintiff, since the complaint was already filed in the name of its proprietor, Engineer Parada. To heed the petitioner's sophistic reasoning is to permit a dubious technicality to frustrate the ends of substantial justice. Okay, we are already clear with who may be parties to an action. Only natural or juridical persons or entities authorized by law may be parties to an action. Now, who is the plaintiff? Who is the defendant? The term plaintiff may refer to the claiming party, the counterclaimant, the cross-claimant, or the third or fourth or etc. party plaintiff. The term defendant may refer to the original defending party, the defendant in a counterclaim, the cross-defendant, or the third or fourth or etc. party defendant.